Hello, my name is Sonda Pauletti, and I'm with the Office for Victims of Crime Training and Technical Assistance Center. Welcome to today's webinar, MDT Cross-Training Prosecutors and MDTs, brought to you by the U.S. Department of Justice, Elder Justice Initiative, and the Office for Victims of Crime Training and Technical Assistance Center. Before we get started with the presentation, I'd like to provide a brief technical overview. The audio for today's webinar will play through your computer. So please make sure that you have speakers or headphones available and that the volume is turned up. And as with all technology, we may experience a momentary lapse in the webinar session. In the event of a problem, please be patient and remain on the line. If you experience an individual technical issue during our webinar, please send a private chat to Jason Adams, our technical specialist, or you can send him an email at jadams@ovcttac.org. We'll be using the chat pod throughout today's webinar. If you have any questions, please type them there, and we will address as many as we can towards the end. We are recording today's webinar, and the recording will be available on the OVC-TTAC and Elder Justice Initiative websites, along with a copy of the PowerPoint in the near future. At this time, I'm going to turn it over to Julie Childs, consultant to the Elder Justice Initiative, to introduce herself and our presenters. Julie?
Thank you, Sonda. Good afternoon, everyone, and thank you for joining this wonderful webinar. The Elder Justice Initiative has a wonderful website that we'd like you to visit as well, ELDERJUSTICE.GOV, where you will find more information about the MDT Technical Assistance Center. You'll find our webinars like this one. Once they're recorded, we post them on the website so that you can find them there. But I also want to just let you know that the mission of the Elder Justice Initiative is to support and coordinate the Department of Justice's enforcement and programmatic efforts to combat elder abuse, neglect, financial fraud, and scams that target older adults. This initiative has many programs for outreach, to promote justice for older adults, to support prosecutors and law enforcement and social services and victim specialists that all work together to fight elder abuse and prevent elder abuse. ELDERJustice.gov has outreach materials, which I just mentioned, but if you go to the website ELDERJustice.gov, you will find more than that. You will find presentations that you can take from the website and give to your community or your peers. The MDT guide and toolkit, which we'll be talking about a little bit more later, is also on the website. There's a prosecutor video series, not only on ELDERJustice.gov, but on our EJI YouTube channel. We have information on financial exploitation and scams. There are statutes and research articles on elder abuse. So we hope to put together a collection of information that will help any elder justice professional or the public looking for information on elder abuse and how to stay safe. So we hope you'll go to those locations and find out more. The Multidisciplinary Team Technical Assistance Center is on our website. It is a fabulous resource that we hope you'll go to on the website, and it is run by Talitha Gwynn Shaver, who couldn't be on the webinar today, but is available to consult and respond to questions about materials for developing an MDT. She's available to do remote consultations to discuss problem solving. She's even able to do, in some cases, in-person consultations for communities needing a more hands-on approach. She's also got information on, well, there's a collection of webinars, there's more educational information. There's an awful lot of good nuggets of helpful information in her MDT guide and toolkit, and we hope you'll go there and take a look. So that's, I think I spoke into the services slide. So you'll go and take a look, we hope, with the MDT Guide and Toolkit. Today we have a fabulous presenter, but before I introduce Lisa Rockmuth, I want to please post a polling question to find out who is attending our webinar today. If you would just take a moment and just fill that out for us, we'd appreciate it. I see the numbers are changing, so that's great. We've got a lot of prosecutors, we've got some social workers, victim services folks, and some other folks, law enforcement and legal. That's terrific. We hope that you all will benefit from the information that you'll learn today, and you'll participate with questions after. Now it's my pleasure to introduce Lisa Rockmuth. Lisa is the Deputy Director of the New York City Elder Abuse Center at Weill Cornell Medical Center, the Division of Geriatrics and Palliative Medicine. That's a mouthful, and she is super experienced. She manages the day-to-day operations of NYCEAC's existing MDTs and is spearheading the expansion of the MDTs to all 5 boroughs in New York. Prior to joining NYCEAC, Lisa was the Director of Clinical Initiatives and Programming for NYC's Human Resource Administration's Office of Domestic Violence. Through these 2 positions, Lisa has worked with systems, communities, and individuals affected by and dedicated to domestic violence and elder abuse. Lisa holds a master degree in social work from the University of Pennsylvania. She has 27 years of social service experience with a particular expertise in child abuse, intergenerational abuse, domestic violence, and housing initiatives for individuals and families. In addition to her years of clinical and administrative experience, Lisa is an experienced workshop curriculum developer and presenter. Lisa is also an adjunct professor at the Silberman School of Social Work and a board member for an organization called Even Footing. So I don't know how she had time to join us, but I'm so glad she did. And Lisa, I will turn it over to you to talk about your recent paper and some of your other wonderful efforts. Please take it away.
Well, thank you so much, Julie, and it's a pleasure to be here with everyone today. This has been just an incredible endeavor to really think about how we can move forward with getting MDTs to the 5 boroughs. And we have had some incredible assistance and input from some key players in this work. And I'm going to talk for a minute about the work that MT Connolly and Risa Brackman have done to really advise us on the role of the prosecutor on the MDTs and how we can really look at how we can help to engage prosecutors and look at the other professionals and the work that they're doing on MDTs to move the agendas forward to diminish risk for vulnerable elders. MDTs are relatively new interventions for elder abuse, and a lot of material still needs to be developed. We're fast moving. We're really trying to help to get people as much information as quickly as possible to inform their decisions around building MDTs. We're currently in the process, as Julie said before, of scaling to the 5 counties in New York City. New York State has initiated MDTs in all of the counties throughout the state by the end of 2020, and it's just an incredible initiative. Each of the 5 counties in New York has their own DA. So when we really looked at the role of the prosecutors on the MDTs, particularly in New York, each county had a different characteristic, had different ways of interacting and working with prosecutors. So it really gave us a broad sense of the role of the prosecutors on the MDTs. We wanted to help people understand the approach and wanted to try and standardize as much as possible so that people would be able to replicate the model, replicate the uses. So the inception of these documents came from scaling of the MDTs. They really came out of our need to understand the role of the individual players on the MDTs, and we had this great opportunity to look at the role of the prosecutors in this case. In creating the document, MT Conley spoke with people on our team in New York City, as well as the DAs and prosecutors throughout New York State, throughout New York City, and then I think she also spoke with a couple of DAs in maybe one or two other states. The document that I'm referencing right now is called The Role of the Prosecutor on the MDTs. It's really been an endeavor to look at how this whole project gets scaled, but also how we can help prosecutors understand their role and really create that synergy between the prosecutors and everyone else on the team. We've also created another document in addition to the role of the prosecutor, and that is a document called The Role of the Civil Legal Attorney on the MDTs. And Candace Heisler worked with all of us, but she worked very specifically with Risa Breckman to help develop this document. Both of these documents will be available on our website, NYSEAC, nyceac.org shortly, and as soon as they're available, I'll send out a blast so that everyone can access them. Thank you, Julie.
Thank you so much, Lisa. I'm just noting the website that you said that it was going to, your paper was going to appear on. Can you just repeat that one for us?
Absolutely. NYEAC.org, NYSEAC.
Okay. So folks on the webinar can look there soon for your paper. Thank you so much. Our second presenter today, appreciate it. Our second presenter today is Nicole Sato, and Nicole is a Deputy District Attorney with the San Mateo County District Attorney's Office in California. Over the course of her 10-year career as a prosecutor, she's handled several different types of cases, ranging from complex fraud, domestic violence, sexual assault, attempted murder, and other violent crimes. Nicole has dedicated the last few years to prosecuting elder abuse as one of two prosecutors assigned to the Elder Abuse Unit at the San Mateo County District Attorney's Office. In addition to participating in community outreach, she's trained law enforcement officers throughout the county on investigating elder abuse cases and was one of the founding members of the Elder Dependent Adult Protection Team in San Mateo County. That sounds super interesting. I hope to learn more about that. Nicole, I'll turn it over to you. Thank you for joining us.
Thank you so much, Julie. I'm very honored to present today. And as a prosecutor, I hope that I can share some perspective to everyone who's tuning in today. And if there are other prosecutors, which it looks like there are on the call, hopefully you will agree with some of my sentiments. But I wanted to start out today by talking about some common misconceptions about prosecutors. There are several out there, and I think that if I can dispel some of those from the beginning, that will help us move forward. The first is that the prosecutor is the victim's personal attorney. While the prosecutor can advocate on behalf of the victim is not our personal client, which pretty much means that if a victim, for example, does not want to go forward in prosecuting a case, that doesn't necessarily mean that the criminal case will end there. Our primary responsibility as prosecutors is to ensure public safety. So we have to evaluate a case on a much larger spectrum. We have to consider the community at large when we go forward with a criminal case. The second misconception that I think is out there is that prosecutors are responsible for investigating the entire case. While we may participate and assist in directing law enforcement in investigating these types of cases, we cannot become a witness in our own case. So, for example, if a victim were to come to me one-on-one and start telling me about all of these things that happened in a particular case, I would then become a witness that could be subject to being subpoenaed in my own case or the case that I'm prosecuting. So we may assist law enforcement officers and provide suggestions to them on investigating the case, but we are not directly responsible for the entire investigation. The third misconception I wanted to address was that if a case is not filed, it is because the prosecutor did not believe the victim. I think there's a lot of frustration in this particular one because oftentimes that is the hardest part of our job, is that we as prosecutors, having met with victims, gotten a rapport with victims, believe the victim. But unfortunately, we have an ethical duty on which cases that we can file and which cases that we cannot pursue. And I will address that ethical duty in a couple slides. Finally, I think this is kind of a widespread misconception in the media, and that's the idea that the prosecutor must obtain a certain percentage of convictions. That is 100% not true. We are bound, again, by an ethical duty in filing cases that we believe we can prove beyond a reasonable doubt. And I'm going to talk about that in a little bit. But I'd like to just kind of go over some of the nuts and bolts about what we as prosecutors do and how a criminal investigation starts for those of you that may not be prosecutors or law enforcement. So anytime our office receives a police report, that is the beginning of review by the prosecutors in our office. So, for example, the police department is the one who's responsible for investigating the case. They will submit a police report as well as maybe some other types of documents with the police report for review. Now, before a case reaches the police department, there are many different sources of information in which they will collect evidence. That could be a concerned citizen. That could be the victim themselves going to the police department to make a report. That could be mandated reporters, such as medical professionals. Often we see cases that begin with Adult Protective Services or the public guardian, a victim's private fiduciary, or the ombudsman. What does a criminal investigation look like? Again, it starts with a police report from our standpoint. We get a police report that's been written by an officer where they will take statements from the victim and from other witnesses who may be aware of facts surrounding what occurred in this particular incident. There are many different types of evidence that we review in addition to police reports. Different types of physical evidence include video surveillance, audio or video recorded interviews with witnesses or the victim, photographs, DNA or fingerprints, 911 calls, data that is contained on a computer, cell phone evidence such as cell phone tower data, text messages, voicemails. All of those things are types of physical evidence that we will see that will accompany a police report. There are also several types of documentary evidence that we review. Bank records, medical records, reports by first responders such as paramedics or firefighters, reports from Adult Protective Services, real estate documents such as deeds, loan, or mortgage paperwork, and also deposition transcripts or other documents from a civil lawsuit. Now, while here in California we may not be able to admit a transcript from a civil case into evidence, These are very valuable sources of information for us as prosecutors. We can use them to impeach witnesses in court, and it generally will give us an idea of what the witness will say when they testify if the case proceeds to a preliminary hearing or a jury trial. Once we receive the police report, we have a decision. We can either file the case immediately, we can decline to file the case, or we can send the report and the case back to the local police agency for follow-up investigation. Oftentimes, the third option, especially in elder abuse, will often happen because many elder abuse cases are complex. They involve things such as bank records, medical records, which may require the officers to get a search warrant. So that will also take additional time. But once we collect all of these things, we will review the report in its entirety along with all of the other different types of evidence that I've mentioned. And the big question is whether the district attorney's office will prosecute a case. Now, I had mentioned earlier a little bit about the ethical burden that we as prosecutors have to bear. This is a responsibility that we as prosecutors take very seriously, as it is grounded in ethics, essentially. And the first question that I will ask myself when I'm reviewing a case is whether I can prove the charges beyond a reasonable doubt. And along with that question is the question of, will a jury convict? If there is a reasonable explanation for evidence that is consistent with lack of guilt, we cannot proceed. We can only file cases that we believe we can prove beyond a reasonable doubt. And the reason for that is, at least in the state of California, the jury will likely be instructed with this very notion. The idea that if there is a side of the story or a version that is consistent with innocence and one that is also consistent with guilt, they must go with the version that points to innocence. So here is an example that we can talk about, and this example was based on a case that actually came through our office, and however the names and some of the details have been changed. Here's our first example. Suspect Myra is the eldest daughter of the 91-year-old victim. The victim's other daughter, Patty, went to the police department with her mother to make a police report. The victim reported that Myra transferred the deed to her residence into Myra's name without her permission. Myra also had power of attorney for her mother. The victim, who had been living in a care facility, stated that Myra had her sign various documents. According to the victim, Myra told her that if she wanted to return home, she needed to sign the documents. The victim thought the documents she was signing were stating that Myra was going to take care of her. Patty, who is the victim's other daughter, also provided a statement to the police. Patty discovered that the deed to her mother's home was now in Myra's name. She did not believe that the victim willingly signed the documents and believed that her sister Myra had in fact tricked her. Police interviewed the suspect, Myra, and according to Myra, she told police that when her father had died, Patty had moved into her mother's home. Myra received a call from Adult Protective Services telling her that her mother had been neglected. Patty was evicted from the residence, and as a result, her mother ended up living in a care facility. Myra took her mother to see an attorney who rewrote her mother's will and excluded Patty from the will. Myra claimed that her mother knew she was putting the house in Myra's name. Myra told police that she suspected Patty was manipulating her mother. There were no issues with regard to the victim's capacity to make financial decisions. This was a case that I ended up reviewing, and we ended up not filing. And the reason why was because of that exact the ethical duty that I had just mentioned, which you have one side of the story, which is you have Myra saying that, her mother was in fact deliberately being manipulated by her sister Patty, and that the mother essentially knew the documents that she was signing. You also have the second version, or the victim side of the story, where she's saying, I thought that the documents I was signing were so that I could essentially leave the care facility, not to give my home to my daughter Myra. This example, I think, conveys many issues that we see, especially in cases, I'm sure many social workers have probably experienced this, with competing family members and family members who do not get along. And, even if that might not be the case to where Patty is not manipulating her mother, that is certainly an argument that I would anticipate a defense attorney to make. And again, going back to that ethical duty, if the jury is presented with one side of the story that reasonably makes sense, that points to innocence, and the other that points to guilt, they will have to go with the side of the story that shows innocence. So that is really tough, and kind of what we look for as prosecutors when we're evaluating cases is corroboration. I want to turn to a second example, and this is an example of physical abuse. Police responded to a report of a domestic dispute at a residence. A neighbor reported hearing a loud commotion coming from the home. Upon arrival, the officers contacted a 75-year-old woman who said that her 40-year-old son pushed her against the wall and slapped her in the face 2 times, causing her to fall to the ground. She was visibly upset and told the officers that she is afraid of him. Police spoke with the woman's son, who denied making physical contact with her. He claimed that his mother was upset over a verbal argument that they had had because she did not approve of his new girlfriend or his spending. The victim did not have any injuries, and no one else saw what happened. This is kind of a classic example of, unfortunately, a domestic violence scenario that we see often coming through the office. And going back to the importance of corroboration, this example is a demonstration of a case where we would likely not file absent additional corroboration for what the victim is saying. There can be small tweaks to the fact pattern that may change a filing decision, but based on these facts alone, with no additional corroboration for the victim's account, we as prosecutors would not be able to prove this case beyond a reasonable doubt. However, that fact pattern may change. If the victim had some evidence, physical injuries that were consistent with what she was saying had happened, I know in this fact pattern it says there's a loud commotion coming from the home. That in and of itself is not necessarily corroboration, because the loud commotion could be also in line with what the suspect is saying, which is that they had a verbal argument. So without any other facts, this would be a very, very difficult case to prove, and one that likely would not be filed. Okay, I wanted to talk a little bit about the prosecutor and their role on the multidisciplinary team. I was able to fortunately have a sneak peek of the paper that Lisa had talked about earlier. I would encourage many people to check out that article, because there are many things that resonated with me as a prosecutor, and I think that others who participate in an MDT would be able to relate to. So I would encourage folks to give it a read if you have a chance. In our county, in San Mateo County, we meet quarterly for our multidisciplinary team meetings, but our county has gone even a step further, and we have formed the Elder Dependent Adult Protection Team. And it's something that I personally am very proud of, and I think the formation of this EDAPT team is an extension or in fact, it is actually a multidisciplinary team. The EDAPT team that we have in our county is comprised of 2 prosecutors, 2 district attorney inspectors from our office, several representatives from Aging and Adult Services, the public guardian, and also members from county council. And often what the EDAPT team would do is, especially in complex financial cases, we would meet as quickly as possible to talk about ways that we could strategize and collaborate in order to pursue or investigate a case more quickly. Because the reality in the elder abuse arena is that our victims are getting older, and they're getting older quickly, which means that the cases, as time passes, become more difficult to prove. So I'm very proud of the EDAPT team and many of the accomplishments that we've had. In addition to collaborating on actual cases, the EDAPT team has done many trainings. We've done outreach in the community, and we're very lucky to have a very, in my opinion, an open dialogue between law enforcement, the district attorney's office, and also Aging and Adult Services. So what are some of the benefits of collaborating with other disciplines? Some of the contributions that can be made by a prosecutor include obtaining a criminal no-contact order for the victim once a criminal case has been filed. The prosecutor can obtain restitution for victims as part of the criminal case. And we can also help facilitate dialogue with law enforcement. And this is an important one, I think, for the rest of the MDT team, because prosecutors work closely with law enforcement. And sometimes, and often what I hear from, say, the social work side and law enforcement is there's a difficulty in having the same dialogue, because I think the culture of law enforcement and the culture of social services is very different. And while both sides aim to and are seeking to obtain justice and make sure that an elderly victim is cared for and is safe, it can be difficult to strategize together in a way that is most effective. And the prosecutor has a unique ability to reach out to law enforcement. I know personally I have known some officers in our county for many, many years, and as the prosecutor's career continues, often the patrol officer who knew the young prosecutor, their career will also continue, and then they may be in a position of sergeant or lieutenant and be able to assist the prosecutor and respond more directly than perhaps a patrol officer might be able to. And those relationships are so important, especially when it comes to getting things done quickly, which I know can be a source of frustration for many social workers. So simply a call to your local prosecutor to maybe follow up on a particular case, or to contact the local police agency to see what's happening with a particular investigation. That is something that your local prosecutor should be able to assist with. And we in the District Attorney's Office in San Mateo County are fortunate enough to have 2 full-time or 2 district attorney inspectors who are also able to assist in that dialogue between law enforcement and the social service side. The prosecutor can also encourage all disciplines to work towards a collective goal. The prosecutor in the position of, filing a criminal case, often the criminal case can control many things. So for example, the criminal case may control what happens in the civil case, whereas the other way around, vice versa, it's not necessarily that a civil case will determine what happens in a criminal case. So we can encourage many parties, social work, law enforcement, and even civil representatives for the victim to work toward a collective goal in order to meet a particular elderly victim's needs. The benefits for the prosecutor are numerous. Particularly, I think in my experience, I don't know if I can speak for other prosecutors, but as a prosecutor, we can learn of potential cases before they're even reported to law enforcement. Again, having that open dialogue with the social services team, with victim witness advocates, that can only benefit the prosecutor to give you a jump start on investigating and prosecuting these cases. Often I find, in my experience, that the Adult Protective Services team in our county often has a long-standing relationship with the victim, and they also have more insight about a victim's family dynamic. That may not necessarily come through in a police report when we receive it on our desk and start reading it. So often I will pick up the phone and call over to someone on the social services side to see what the victim's family situation is and how the victim is doing, both physically, mentally, and emotionally. Other disciplines may have already achieved a victim's trust. Often elderly people, especially if they're isolated, may be reluctant to trust someone in a uniform from law enforcement or someone in a suit, a prosecutor. So definitely it can work to our advantage as prosecutors to stay in touch with other disciplines, to understand their relationship with the victim, and that can only make for a more effective prosecution. We can also obtain evidence or information needed for criminal prosecution much faster. So for example, if we have a victim who is conserved, the public guardian is able to obtain things like bank records and medical records, which otherwise we would be required to seek a search warrant, most likely, to obtain some of those things. And that's maybe the fastest way for a social worker to make friends with the police officer investigating the case, is to inform the officer that you have access, and very quick access, to some of these types of evidence. One of the things that I am most proud of, in fact, I think in probably my entire career as a prosecutor, was a case that I recently tried. And this is a success story for all, I think, multidisciplinary teams. And I wanted to share this example with you today because it is one that is very near and dear to my heart. And so this particular case, it was a jury trial that lasted 3 weeks. The victim was 80 years old. He was autistic, and he was also diagnosed with stage 3 lymphoma cancer. He had been admitted to the hospital when a nurse checked in on him at his home and found him weak and lying in his own feces and urine. The victim had not a soul in this world. He had no friends, no family. He lived alone, and in fact, he had been taking the bus to many of his chemotherapy appointments, which, as you can imagine, would be an incredible feat. The defendant in the case worked for a board and care placement agency and was introduced to the victim in order to help place him at a board and care facility. Within 2 days of meeting the victim at the hospital for the first time, the defendant had the victim pretty much sign over his entire life to him. He signed over the deed to his home, which was transferred into the name of the defendant's limited liability company. And he also had the victim sign a durable power of attorney, and also a separate power of attorney that was filed with the victim's banking institution. The victim thought he was signing paperwork to consolidate his assets. The defendant recorded the deed and power of attorney at the county recorder's office before the ink on the paper was barely dry. Although the defendant claimed to have left a $150,000 check with the victim never received any money for his home. And keeping in mind that this entire transaction had happened when the victim was still in his hospital bed, the victim, on top of having cancer, being incredibly weak with a fever, also was suffering from sepsis, on top of being autistic and being very, very weak. The victim also had a reverse mortgage on his home that was never paid off. During an interview with police and a representative from the social services end, a representative from Aging and Adult Services, The defendant denied any affiliation with the limited liability company and denied living at the address that was associated with the company. We confirmed that the defendant was in fact listed as the owner of the LLC with the Secretary of State. The officers who investigated the case executed a search warrant at his business address and also his home. And they seized a computer that showed that the defendant was actively forging and manufacturing documents very quickly after he had been arrested and posted bail. While we were prosecuting this case, we came across several issues along the way. The victim also had a civil lawsuit that his private fiduciary had filed on his behalf to get the house back. While the criminal case was still pending, the victim had signed a declaration under penalty of perjury attesting to several damaging facts set forth by the defendant. That was an incredible blow to the case, and any defense attorney, I'm sure, would be overjoyed when they see that the victim is swearing under penalty of perjury that he knew pretty much that he was signing his house over to the defendant. The notary public also, who had witnessed the signing of the documents, testified at a civil deposition that the victim appeared to understand that he was signing over the deed to his home. Now, all of these seemed to be almost insurmountable issues when we were immediately faced with them, but as we started to work through the case, there were several things that helped overcome these issues in front of the jury. We were able to show that the notary public who actually testified in the criminal case had known the defendant and had in fact had much more of a relationship with the defendant than he admitted to at trial. And as the trial proceeded, the victim's fiduciary testified that pretty much the victim was so vulnerable and so gullible that he would sign away anything that you put in front of him. And I think that that was clear to the jury when they heard the victim's videotaped testimony. The trial lasted 3 weeks. Sadly, the victim ended up passing away 2 years, exactly 2 years to the day that he had signed the deed to his home, and that was before the trial had begun. But here in California, we as prosecutors have a special tool that we are able to use in prosecuting elder abuse cases. We have the ability to videotape and conduct conditional examinations of a victim to prevent this exact scenario. The law recognizes that when we prosecute elder abuse cases, that elderly victims, there's a high likelihood that they may pass away before trial comes. So we were able to preserve his testimony for trial, and he in fact testified 3 times in the criminal case, and we played all 3 videos of his testimony for the jury. Several witnesses testified, investigators, nurses, representatives from Aging and Adult Services, a neuropsychologist who had evaluated the victim and testified that although he did not completely lack capacity to make financial decisions, he was certainly cognitively impaired. The notary public, as I mentioned, also testified. And in addition, we called an expert geriatrician who reviewed all of the victim's medical records from the period of time when he was hospitalized at the hospital, and she was able to weigh in on the effects of not only his cognitive impairment, but also his physical limitations at that particular time. She was able to paint a picture for the jury as to what our victim, how he would have appeared, his weakness, and was able to interpret many of the medical records that we admitted into evidence. After a little less than a day of deliberations, the jury found the defendant guilty of both felony counts, which in California was theft from an elder, Penal Code Section 368, subsection D, and count 2, which was filing of a false document, which is Penal Code Section 115. this to me was a fantastic example of what can happen when you have a proactive multidisciplinary team. You have, in this scenario, we had dedicated nursing staff who cared very deeply for the victim, who communicated with me directly throughout the trial, and then also with law enforcement, and they were able to assist law enforcement when the investigating officer wanted to meet with the victim. In addition, the representative from Aging and Adult Services actually participated in the interview with the suspect. The detective who was investigating the case was a very good detective, but he did not have as much insight as to complex financial transactions. So she was able to guide him in the interview with the suspect. And when you have all of these players, talking to each other and having an open dialogue, this is an example of what you can achieve, I think, as a multidisciplinary team, and this is an example of something to really strive for. And I know I just have a couple more minutes, so I want to talk about just a couple important lessons. Collaboration with different agencies and involved parties is critical to more efficient, effective prosecution and investigation. And I think it's important to be mindful that we have to be supportive of one another and each other's roles. There is the reality that we have these competing cultures. There's the law enforcement culture where they're looking to, they're very heavily burdened with multiple cases that they're investigating, and they have to respond to calls of safety first and foremost. In reading the paper that Lisa had discussed earlier, there was a portion in the paper that discussed how prosecutors are trained to be persuasive, which that's our culture. We make arguments in front of a judge on a daily basis, but that can impact some of the other players on the MDT team who may feel intimidated by the prosecutor, by the prosecutor's style. And then there's the social work aspect, and the social workers have such an important job because they're the ones who are on the ground floor with the victim. They're meeting and speaking with the victim probably the most often out of many on the MDT team. And so it's important to know that we're all coming at this with a unified purpose. We all want the elderly population to be free from abuse, and we are all on the same team. We have to remember that, and I also like this in the paper that Lisa had been discussing, to not measure success by criminal convictions. Celebrate the small wins. Just because a case doesn't end up being filed in the criminal arena doesn't mean that we can't make great strides on the MDT team. Whether that's assisting the victim in obtaining a civil restraining order, or just merely providing social support for the victim, which so many of our elderly victims need. Finally, do not be discouraged from calling or contacting the prosecutor. Prosecutors are very busy. We are in court very often, and so if you call or email and we don't get back to you immediately, don't be discouraged and feel free to just pick it up, because it could have been, when we are in trial, which are very, very stressful times for prosecutors. So I encourage you to keep that dialogue open and to contact the prosecutor as often as you wish or would like to. And one more final thought. I know we're probably going to open this up for questions pretty soon. But I think, if you operate the MDT from the perspective that it is imperfect and you can always better your communication, you can always strive to improve your MDT team, whether that's facilitating more dialogue. It's important to continue striving to better your team and to better yourself and to better your contributions to the MDT team, because the end result, if everyone is striving to improve, is that you'll have more efficient and effective criminal investigations, prosecution, and just in general outcomes for the elderly victims. And I wanted to thank each of you who are tuning in today for the work that you do to protect and serve our elderly communities, which is so important. And I appreciate everyone who's listening. Thank you for tuning in, and I will turn this back to Julie.
Thank you so much, Nicole. There was just so much information. Some of those stories were riveting. So glad that you were there to help, and your team. And I'm so glad that we are talking about MDTs in this capacity, because not, as you were mentioning, not every case that you bring will go through to prosecution, but you have fail-safes put in through these MDTs to make sure that they still get help. And that's really, I think, the end game for most of us working in elder abuse field, is to make sure that they get help.
That's right.
All right. Well, I've got a couple of questions teed up, and I would like to start with the one from Kendra Cooper. She's asking, please elaborate on the role of undue influence and misrepresentation on the elder victim. For example, this sweetheart scammer, how do you counter that?
So, and I can't speak to all different jurisdictions. I know in California, unfortunately, we cannot, undue influence is not a jury instruction that we would necessarily get in the criminal context. In the civil arena, I know there are specific jury instructions for undue influence. If we were prosecuting a theft case based on like misrepresentation, there are several different theories that we could pursue. There's theft by trick and also theft by false pretenses. The example, the success story that I had talked about, that scenario was a theory of theft by false pretenses, because we have the active misrepresentation to a victim who clearly had been defrauded based on these misrepresentations by the defendant. Let's see here. I don't know if that fully answers the question. In sweetheart scammers, we have seen those types of cases, and generally those are on the same exact theory that I just talked about, which would be theft by false pretenses. If we were to pursue a different theory of just straight larceny or theft, and the victim, for example, lacks capacity. So say you have a sweetheart scammer who moves in on someone who has dementia and clearly cannot make financial or medical decisions on their own, that is another theory that we could proceed. But we would need to show that the victim was not capable of consenting to the financial transaction. And so in those types of cases, we would generally like to have a capacity evaluation conducted by a neuropsychologist who would be able to weigh in at the time of trial that the victim was not capable of forming consent to the financial transaction. And there's also another added requirement. The perpetrator must know or reasonably should know that the victim cannot consent. So it's not simply enough that a neuropsychologist would opine that the victim cannot consent to a financial transaction. It has to be reasonably apparent to the perpetrator.
That's very interesting. My goodness. I'm going to come back to Kendra Cooper's second question and go to Gerald Carr's question. And I think maybe this touches some of the work that Lisa's been doing. He's asking, what percentage of victims are victimized by elderly perpetrators? I'm not sure we know exact statistics, but...
Yeah, I personally don't have any statistics, so I don't know if Lisa can maybe speak to that.
I don't have specific statistics. I think when we talk about intimate partner violence and the intersection of intimate partner violence with elder abuse, we can probably look at those numbers and draw some conclusions from those numbers, but I think that would be really difficult to glean because, you know, we'd really have to go case by case. I don't know if that's the number.
Yeah, go ahead. That kind of highlights the need for more research and more data, and more data collection in this field in general, so we can peel back the onion on that.
Yeah, I can only speak to my experience personally, and the cases that I've seen. It's a pretty small section of elderly perpetrators. Typically, the perpetrators that we see are unfortunately often relatives or caretakers, someone who is more physically able to take care of an elderly victim. So I would say, in my experience, what I've seen, it's a very small percentage. But I don't know how, what the official statistics are on that.
Yeah. Well, let me go to Kendra Cooper's other question, which was kind of a scenario. The elder victim loses $100,000 but sympathizes with their abusers. Where will they go? What will they do? And does that preclude prosecution?
Well, it depends. It depends, and it's a very fact-specific, I guess my answer has to be very fact-specific. It depends on what some of the other facts are. If that particular victim, for example, lacks capacity, and that is apparent to, reasonably apparent, then we may be able to prosecute that case. Unfortunately, if it's a scenario where the victim, is being taken advantage of, but then is telling police, oh, but I feel like it's okay, I gave them permission, at the time, I don't want it to happen anymore, that unfortunately is a scenario that we may not be able to prosecute absent other corroborating evidence. So, for example, if there was another victim who came forward who said that the suspect had been doing exactly the same thing, and we see a pattern with other victims, that can be great corroborating evidence. In fact, we've seen cases similar to that in our county that we have prosecuted and gotten some good results on. If we cannot prosecute a case and go forward on a criminal case, that's where the importance of the MDT team comes in. The social workers, would be able, I would hope, be able to provide some means of assistance for the victim and either trying to get them away from the abuser, encouraging the victim to obtain a civil restraining order in place, or maybe, if the victim lacks capacity, evaluating the victim to see if they are still able to make financial decisions. I know we have resources here and access to neuropsychologists who may be able to start that evaluation to see, maybe this victim is not someone who's able to consent to financial transactions generally. And they can start that inquiry.
Thank you so much, Nicole. I did want to make one plug before we wrap up. We're down to 2 minutes. I'm sorry, there's a few more questions, but we also have the opportunity for you to talk to the MDT Technical Assistance Center lead, Talitha Gwynn Shaver. Her information is on the slide here. Please do reach out to her for more information about forming and managing multidisciplinary teams. Also, you can send questions to elder.justice@usdoj.gov if you haven't had time to put them in. I do want to mention that we have, I know Nicole was mentioning working with law enforcement, and so was Lisa. We have a tool, it's a web module called the Elder Abuse Guide for Law Enforcement, and it's available online. If you go to ELDERJUSTICE.GOV, you can get right to it, and it has a little training YouTube video with it. It is something that you can on the fly learn about elder abuse, but also find out more information on how to respond to elder abuse for law enforcement, first on the scene, first responders. It's just got chock full of information. We've just uploaded statutes and plan to put in more charging information. So with that, I think we're out of time. And I want to thank everybody for joining the webinar today. Thank you so much, Nicole and Lisa, for presenting so much great information, and to you, Jason and Sanda, for all of your technical support.
Thank you.
Thank you.